most of our lives, especially during lockdown, have transferred from the physical space to the digital space. And that raises the question, what kind of rules are there for these platforms which are so direct? You can reach a large mass of people directly in the same time, and almost as if you were face to face, but you're not. So what kind of rules and legislation are required, and what kind of rights do we have? Now, I'm very excited to be talking about this today with all these lovely and wonderful scholars on this topic. And without further ado, I'd therefore like to introduce the first guest for today, Mr. Dennis Redeker, who is from the University of Bremen and whose research areas are internet governance and the theory of digital constitution. So without further ado, Dennis, the floor is yours.
Thank you very much. And indeed, I'm also teaching Introduction to American Politics here at the University of Bremen, so that's quite fitting. Thank you for having me. So my turn is really shortly to lay out the empirical occurrences that give rise to this panel and to the discussions that both the social media companies had to have internally, and the discussions that we as a society and as societies are having about who should be able to post what on Twitter, and particularly what the President of the United States should be allowed to post on Twitter and Facebook and so on. So I'll first talk a little bit about the January 6th Capitol riots, and then I'll talk a little bit about the reactions of the social media companies before then we hand it on to you panelists to discuss this. What should be said first maybe is that Donald J. Trump had been a president like no other before in using social media, Twitter particularly, almost 90 million followers before he was banned. Advisor or a spokesperson actually to the president said that these are indeed official statements that are tweeted, if not orders to his administration, at least official statements by the President of the United States. His tweets, Donald Trump's tweets, had been discussed by media and by the political system in the United States and beyond whenever they came about. And it was more than 20,000 tweets during his presidential term. And even before the 6th of January Capitol riots, President Trump had a run-in with the social media companies who had started to either hiding or adding warnings to some of his tweets based on things said about the pandemic, COVID-19 pandemic, and also the then ongoing elections in the United States. The results of the US presidential elections are being certified by Congress by a joint session of the Senate and the House of Representatives. That took place for the last time now on 6th of January 2021 in Washington, D.C. in the Capitol building. It was that day that also Donald Trump invited his supporters and followers to the White House, and outside of the White House, he held a rally during the time that the votes of the different states were certified in a Capitol building. There he already made statements to the fact of denying the validity of the elections. And he made statements that were, at least judged by many, supposed to have produced the effect that these supporters went onto the Capitol building afterward, leading to a storming, as you all know, a storming of the Capitol building in the afternoon of the 6th of January. It was at the time that the two chambers were discussing separately about an objection made to the entire process, and the storming took place that cost 5 lives, that had hundreds of injuries to those policemen and other security personnel defending the Capitol. Thousands of protesters actually made their way into the building, and both the vice president and also the members of the House of Representatives and of Senate had to be evacuated from the building. In the aftermath, this has gone global, obviously, in terms of the media outreach, and almost 400 people have been charged. There were 68 arrests on the day. So this was as many have said, a horrific, horrible moment for the US democracy. Now, on the day itself, Trump actually made some statements that were, although trying to hem in that Capitol riot, were also apologetic for those who were engaged in it. Twitter, and that's Twitter's reaction now, Twitter reacted in such a way as to force the president to retract those tweets, or otherwise within 12 hours, or otherwise blocking the account. The president did so, but he was also warned that repeated infringements on the terms and conditions of Twitter would in fact be used against him, and then his account would be banned. On the 8th of January, then Trump made two different remarks on Twitter again, and both of them were together judged in Twitter's interpretation as received on and off Twitter in such a way that there was a risk for further incitement of violence. And this is the reason why Twitter then banned the account of the president of the United States, who tried to use other accounts afterward, but all those were also banned in the days later. And President Trump then went onto other platforms, rather smaller platforms, to conduct his business. At the same time, Facebook also decided to ban the accounts of the President of the United States, in fact, for at least 2 weeks, but indefinitely. And Facebook then referred that decision to its newly created oversight board. The oversight board is a body that Facebook set up to make some hard content governance decisions, and it is set up in such a way that it is at least meant to be independent of the company, yet at the same time have a binding effect on the company. And that decision by the oversight board hasn't been made, and so the accounts by Donald Trump are still banned by both Twitter and Facebook and Instagram today. Maybe that just as an empirical background to our discussions that could start now.
Many thanks, Dennis, for this introduction. And hello, everyone. My name is Edoardo Celeste, and I'm Assistant Professor in Law, Technology and Innovation at the School of Law and Government of TCU. Let me thank our co-organizers at the Dublin Law and Politics Review and its editor, Mooij, for introducing this workshop today, online event, which is also hosted by the Law and Tech Research Cluster, a new research group established at the DCU Law Research Center. So let me now open a fantastic roundtable. We have with us today 5 excellent speakers, all renowned experts in different disciplines who have been working on topics related to social media, online content moderation. So let me start by introducing our first speaker, Professor Maura Conway, Paddy Moriarty Professor of Government and International Studies at the School of Law and Government of TCU, and also the coordinator of VoxPol, an EU-funded project on violent online political extremism. So Maura research interests are in the area of terrorism, the internet, including cyber terrorism. And today, in relation to this topic, I would like to start this roundtable together with you. And I would like to ask you a question, Maura, to break the ice. So in your studies, essentially, you analyzed also terrorist practice, especially focusing on jihadism. So what we have now seen with Trump is not something new, probably. So what are the differences with what occurred in the past with jihadi extremism? Are we talking about something completely new, or are there some similarities?
Yeah, thanks, Eduardo. Nice to see everybody on the panel, and hi to everybody who's joined. I guess Dennis, in terms of his scene setting, talked mostly about former U.S. President Trump, which is interesting in itself. I'm more interested in the wider issue of the wide deplatforming of what might be broadly termed the far right, or if one wishes, in some cases, the extreme right, in the wake of the same of those events at the U.S. Capitol, in which obviously former U.S. President Trump was also implicated. You know, a couple of the things that struck me about the attention that this deplatforming got, because this came to be a major part of the narrative, was the more wide-scale deplatforming that happened fairly swiftly after those events at the US Capitol. And I think two things in particular struck me. One was, it was if this had never happened before, that we didn't know that the online could spill over into the offline or into the real world. Which was frankly astounding to me as a sort of a framing or a kind of a narrative, because it's not just researchers who had an awareness of this for a very long time now, but there's also masses of reporting about other instances where this had occurred. And the second thing that occurred to me, so I think this very much had to do with US context. And I think the deplatforming issue number two, also, these two things are very much interrelated in the sense that it was if a deplatforming of this type had never previously taken place either, which is also neither true nor accurate. So one of the things that interested me was in terms of thinking things through, was the similarities and differences between what happened in the wake of January 6th as regards deplatforming of the far/extreme right, versus what had happened previously with respect to other extremists. The aspect that's most interesting to me is looking at the extreme right versus the jihadis, because this is something that actually got, as the days moved on, this is something that began to get attention. So people began to point out, you know, a major deplatforming has already happened. The jihadis were deplatformed. In particular, so-called Islamic State was widely deplatformed by the same companies that deplatformed the extreme right in the wake of the 6th of January. I will say, though, that actually major social media companies had also undertaken some fairly serious deplatforming of extreme right users even previous to January 6th, which I think was also overlooked. From approximately 2016, 2017 in particular, there's changes made to terms of service by Twitter, for example, and then others that had some pretty serious impacts for a lot of prominent extreme right users. I'm happy to talk about the similarities and differences between the deplatforming of the extreme right and IS. I will just say that I think there's a whole bunch of interesting factors at play. There's some similarities between what happened, but there's some pretty distinct differences. And I guess for me, an important difference is that you know, IS it was actually an organization or a group as traditionally understood. It was swiftly agreed after its emergence by most countries to be a terrorist group. And that makes it much easier to deplatform than either something called extremists, in inverted commas, or things that are not groups. For example, some kind of an amorphous movement that you could call the far right or the extreme right. Then there's a bunch of other issues around, you know, ideas about self and otherness. The ISIS can definitely be held up as, in inverted commas, as sort of an evil other. we're much more interested in the nuances of extreme right activity. And also the extreme right has a major constituency in the Western world, and ISIS just didn't. So those are some of the issues that I think are interesting to think through with respect to what happened around the wider online deplatforming that took place in the wake of the events at the US Capitol.
Many thanks, Maura, for this first answer, and we'll have probably opportunity to come back to some of the points that you raised later in the panel discussion. Let me also say that we have organized this roundtable discussion in an open fashion, in the sense that we will be accepting questions from the audience. So feel free also to raise your hand if you want, using the button on Zoom, or to simply type your question in the chat forum. My colleague Dennis Redeker will then take care of collecting all the questions. And please specify, if you can, your name, potentially your affiliation if you have one, and to whom the question is directed. So let me then introduce our second speaker, Eugenia Siapera, Professor of Information and Communication Studies and Head of the School of Communications at University College Dublin. Eugenia also works in the area of digital and social media, political communication and journalism. She has recently completed an IRC funded project on racist hate speech in the Irish digital sphere. And she's also working on a project on the digital memory of conflict funded by the European Commission. So my question then to Eugenia would be connected to a research, because Trump's conduct on Twitter, as Dennis said at the beginning of this workshop, was deemed to infringe the platform's rule about incitement to violence, which is somehow a form of hate speech. So my opening question to Eugenia would be if you agree about this interpretation. So we know that, of course, the interpretation of what Trump affirmed on Twitter is, of course, subjective. And what do you think was Trump's biggest mistake in this context? So where to draw the line, in other words, between what is hate speech and what is not, especially in the political context?
Thank you, Edoardo. Thank you for inviting me here. That's a very interesting and I suppose challenging question. Let me just begin by giving you some context. And I'm sure Maura will remember this, but back in when was it now? 2016, I think, when we had the Brussels attacks. Even before that, during the Paris attacks, we did a large Twitter study, and that was even before Trump received the nomination to run for elections. We could see that already then he was the top network. He was heading the biggest network of people who were tweeting about these events, and you can understand what they were tweeting about, right? They were extremely Islamophobic discourses, anti-Muslim, anti-migrant. A lot of these tweets were quite clearly hateful, especially within like the European Union context of what is considered to be legal hate speech. And then after that, we did another study again around like the hashtags related to refugees. And then we could see Trump being like, again, a very big network, and then other players within Europe, for example, at the time, the new player of the Alternative for Deutschland, AfD, and others within the European sphere. So I suppose like all of this was there even then, even at the time before he even became president. But when he did become president, the difference was that no one could basically take him down because he was the president of the free world, right? So you couldn't, like the companies were at a loss, I suppose, in terms of how to deal with this, because you had someone who was actively kind of like spewing out hate. And then at the same time, he was like an elected president of like the most powerful country on earth. So I suppose there we saw very much the limits of what these companies are doing and are meant to do, because how can they govern something that is basically a public, should be a public good, should be seen as in terms of like the public interest, and yet you have private companies trying to decide, and they cannot even decide in a free manner, because who's to say that the next day someone like Trump would, you know, prohibit them from like even operating in the context of the US. So now when it comes to what we consider to be hate speech, and there is a lot of work done on this topic, I suppose like in different regions, this is defined differently. What we found in our research was that this is the research of my student collaborator Paloma Viejo-Otero, who's I think she's participating here, so she can give us a little bit more information. But we see that that this has historically changed and shifted from, let's say, around the end of the Second World War and the Declaration of Human Rights, and through other various treaties. Then there was a huge kind of like issue in American campuses that kind of then again made prominent the question of how, what we accept, what we define as hate speech. And then subsequently the European Union, the determining regulation is the 2008 framework decision on combating forms of racism and xenophobia through criminal law. And this is really the backbone. So, for example, in the European Union, the Holocaust denial is illegal, or should be in principle illegal across all European Union countries, although it's not practiced in this manner. So it's a very long discussion, and I can't do it justice here. I will just maybe pose the question: who will decide what is hate speech? Because a lot of the times we see those targeted excluded from both definitions and from participating in deliberations around these definitions. And also, should everyone have equal right to determine what is hate speech, so that the let's say the contribution of someone who's targeted has does it have to have the same weight as the contribution of someone who is doing the targeting? So I'll just stop here, and perhaps we can pick up some of these threads later. Thank you.
Many thanks, Eugenia, for also to raise this last question about the definition of hate speech, and also more, I think that in our work about terrorist content, they worked on the definition of what is terrorism and what is terrorist content. And indeed, what we can observe is that if you look at the different rules, the internal rules of all the social media platforms, we notice an apparent inconsistency in terms of definition. And of course, this is more the reflection from a legal perspective. Law does not help in this sense, because law lags certainly behind. The legislator did not help so far, and also from the European Union, we can also lament a certain delay. We can certainly talk about this issue later, but let me now introduce our third speaker. Professor Tanya Lokot, Associate Professor in Digital Media and Society at the School of Communications of DCU. Tanya researches in the area of protest and digital media, especially in countries such as Ukraine and Russia, as well in the area of internet freedom, censorship, and internet governance in Eastern Europe. She just published her new book now in March 2021, Beyond the Protest Square, Digital Media and Augmented Dissent. And she's currently the PI of a new project, Mediatize the EU, funded by the H2020 program. So, Tanya, I would like then to start from your recent work, Beyond the Protest Square. So you studied, I guess, especially non-democratic or authoritarian regimes. So my question would be how Trump's deplatforming was viewed then by states with authoritarian regime or with less free internet?
Thanks, Edoardo. And again, thanks for having me on this wonderful panel. I think that seems to be the key question, right? And I think as Maura pointed out, it is very much worth taking a much broader view of, Trump's deplatforming and considering how it's viewed, not just in the US, together with this surprise about the online spilling into the offline, and just the implications of both the decisions that the platforms made and, how they were framed by, say, the US government. So for instance, I can say that, the key question is whether or not such a deplatforming of a powerful person and then of, a whole bunch of other people involved in the unrest that came after, if that could be seen as a violation of the freedom of speech, because I think that is the key question that many other countries around the world that these platforms also operate in are now trying to wrestle with, right? So on the one hand, we can see that in countries that are, we could label as democratic, right? There is perhaps a lot of consternation and sort of caution. Like many EU countries have critically reacted to this because they don't see platforms as the right actors to be making these decisions, right? Because they are private companies, and so it's not really up to them to decide, which actors who are powerful can remain on these platforms or should be put off such platforms. On the other hand, the argument there is that, well, can we really say that this is something that violates Trump's freedom of speech, right? I mean, social media are just one platform. He, as a very powerful actor, perhaps one of the most powerful actors in the world, has a lot of different other platforms where he can speak, including, the Rose Garden, where he can go out and give a press conference, which will be televised. So really, this is hardly silencing his freedom of speech because he still has all of those other viable alternatives, which is the legal term, right? So there's this conflict between somebody saying, oh, well, they're silencing me, and saying, well, you're so powerful, it's really hard to silence you. So even if we remove a couple of accounts because they violate our terms of service, that doesn't really make you somehow to have less freedom of speech. On the other hand, there is a different position, which is espoused by less free states, so authoritarian or quasi-authoritarian countries like Russia or Turkey, where we've also seen some consternation in this regard. They were also quite critical of Trump's deplatforming and of the persecution of perhaps not so critical of the rioters or protesters who were deplatformed or who were prosecuted. But in terms of Trump, I think Russia in particular was really concerned about this because they see it as a threat to their own state officials and to the people in power. So, for them, it's like, well, if they can remove Trump, any other official in any other country is game and nobody is protected. On the other hand, this has also given them ammunition. To just kind of really harden their line on how they deal with platforms and the decisions that platforms make that may or may not coincide with the decisions that their own courts or their own law enforcement has made in terms of what should be blocked and what should be removed and what should stay up. So in Russia, for instance, there's an active discussion around a bill in parliament that would sanction social media platforms for removing or blocking Russian state-sponsored media or state officials. So, if something like RT, Russia Today, gets blocked, which it has in the past gotten blocked, for instance, for spreading misinformation, that would then violate this proposed law, which they would see as, this is a suppression of freedom of speech. In Poland, for instance, they went a step further and proposed new rules seeking to prevent platforms from removing content that national laws deem legitimate. So in Poland, for instance, there's a proposal now from the Polish government that would ban social media companies from deleting content unless it's illegal under Polish law. So, LGBT hate speech is not illegal under Polish law. So you know, they don't have to remove it. And if they remove it, they might actually get in trouble. So I think, again, it's really important to consider the effects of these decisions, not just on the platforms, but on how that reverberates into how different countries who have very different interests change or amend or develop their legislation around regulating online speech. Because I think the effects, we're already seeing the effects, and it's always worth keeping that perspective that, you know, this is not unique. Lots of other people have been deplatformed, but in this particular case, it is such an important set of decisions that it will impact how platforms are regulated and how they're policed around the world, and not just in the US. So I'll stop there for now.
Many thanks, Tanya, especially for raising the point about the fact that the platforming Trump probably does not equate to silence, actually, the president of the United States, with let's remember that he's also like a billionaire. He's managing also, I mean, influencing media companies and so on. So he might have viable alternative ways of spreading his news. From a legal perspective, it's interesting to see that, strictly speaking, this argument, I'm afraid that would not actually gain so much attention, because from a legal perspective, actually, you have to treat all media somehow equally. And if one wants actually to draw a sort of like mathematical calculation of the possibility that Trump has actually to communicate his opinion, one has to admit that by the platforming Trump from the major social media account, of course, his possibility to communicate is, of course, not nullified, but significantly reduced. So it will also be interesting actually to discuss with the audience, what do you think about it? Is it legitimate to allow major social media platforms to ban important political actors? Is there any difference between political actors and common ordinary citizens? So this might be a question for us later for the discussion. But now I would like to move to our fourth speaker, and actually remind also the audience that the chat is still open. So if you want to type your question, feel free to do so. So we slightly change then the angle of our discussion, because it's our pleasure to have Associate Professor Suzanne Little from the School of Computing here at Dublin City University. So Suzanne is also a Science Foundation Ireland principal investigator at the Insight Center for Data Analytics. So she works in multimedia analytics, semantic search, data integration. She has been working over the past few years in a variety of applications domains, including security, technology-enhanced learning, biomedical, multimedia archives, but also autonomous vehicles, Internet of Things, and smart communities. But especially she worked on tools such as machine learning, data management, and computer vision. And indeed, machine learning, but more broadly speaking, artificial intelligence, is one of the tools that social media companies had to implement and incorporate within their platform. We all know that the amount of content that is published on social media every day is huge, and that social media platforms therefore decided to resort to the use of artificial intelligence to detect and to delete potentially unlawful content. Here, what I would like to hear from Professor Little is, from a technical perspective, what are the challenges and also the limitations of machine learning in the field of online content moderation? Suzanne, the screen is yours.
Thanks very much, Edoardo. So I am the odd one out in this panel, I think, from my background, and it's been fascinating to hear the discussion so far. I have worked previously with both Eugenia and Maura on connected issues, but I guess my interesting thing here is to talk about the fact that you could argue that technology has caused this problem right? The incredible speed and scale of reach that's facilitated by mainstream or major social media platforms tends to exaggerate or emphasize, you know, the issues that are happening here. So the natural response is, well, can't technology fix the problem? You know, can we teach the system to assist so that the speed and scale of the response can match the speed and scale of the potential reach? Of course, to do that, we have to do content analysis and then somehow rate or classify the material that's being posted according to a measure, and then deal with that according to some set of principles. And it's great, Maura and Eugenia have both given tremendous examples of why that's actually really, really hard. You know, computers are very absolute, right? They're all ones and zeros. It's very difficult to teach subtlety or gradients to computer systems. It's one of the big things that we work on in terms of refining the sort of work that I do. And a lot of times you have to be very conscious of a compromise between your precision and your accuracy. So it's very, very difficult to get both, right? So you might be able to find all of the objectionable content, assuming you can decide what that means. But you'll also probably include in that net a lot of perfectly fine content. Is that okay? Are you actually causing greater problems by putting a bigger barrier to posting, you know, unlawful or objectionable content? Of course, the reverse is you go, well, no, I can't subdue speech by, you know, accidentally classifying people's posts as objectionable. So therefore, I'll dial down my sensitivity of my system. I'll become more precise or more accurate, but I'll potentially therefore miss a lot of content that I would have otherwise captured. So all of that assumes that we as humans can identify and agree upon terms and definitions that, as we've seen, are very subjective, they're very relative, they're very amorphous, and they change very quickly. So my experience has been both in the work that I did with Eugenia and some current work that we're doing on classifying objectionable memes, so offensive memes, not even anything very strict in terms of the legal requirements, but something that just has the potential to cause offense, that the technology isn't the wonderful universal savior in this case. So the response is often to say, well, surely the companies can implement artificial intelligence to, you know, prevent this from happening. And the answer is, unfortunately, it's far more complicated than that. Does that mean we throw technological solutions out? No. They can obviously improve response time, and they can obviously supplement and help because they can work at a scale far greater than a group of humans can in terms of reviewing. But it's also very important to be aware of the limitations of that kind of content. And I'm sure you've seen things like this where, you know, Facebook will have banned a perfectly innocent post about breastfeeding because it breaks the laws that they have about nudity in content. So there's always this tension between you know, the unknowing consequences of deploying technology at scale, but the need to use technology to address the challenge of scale. So that's what keeps us having interesting discussions, at least, and we live in hope of finding solutions that can help in these sorts of circumstances.
Many thanks, Suzanne. You're certainly right. Technology cannot be the panacea of this problem, cannot solve all the issues related to online content governance. And this is also one of the reasons why platforms such as Facebook decided to introduce the Oversight Board. So Dennis mentioned at the beginning of this workshop that the Oversight Board has now the delicate duty also of determining whether the Facebook's decision of the platforming Trump was legitimate, or at least let's not use the term legitimate, but was in line with the platform's rules or not. I will now ask our last speaker, Dr. Rishi Gulati, who is assistant professor in law at the School of Law and Government, international lawyer, and a specialist in private international law, to comment essentially on this point. So from a legal perspective, Rishi, we are witnessing something new, because Facebook recently created the Oversight Board is a new, let's say, jurisdictional body, but is a private jurisdictional body. So what is your opinion on this phenomenon? Are we observing a phenomenon of, let's say, hybridization of the jurisdictional models from a legal perspective?
Many thanks, Edoardo, for inviting me. And I think in answering your question, I also want to lean on some of the very interesting points that really have been made by every speaker. So forgive me if I get to your answer in a slightly longer format. So as Dennis said at the outset, the capital events have really left an indelible mark that in perhaps the supreme democracy of our times, its own people entered Congress and did what they did. Although that being said, I'm quite astonished that some of those things, yes, there's hundreds of prosecutions going on and more will, are already being started to be overtaken by events, which is actually quite concerning. So before getting to the Facebook Oversight Board, it's quite clear that for a very long time through Twitter and Facebook and through the mass media, Trump was engaging in a broad speech or category of conduct where he was openly undermining the threat from armed groups and saying that the election would be stolen. And once the election was done, also really contesting the result of what, from all evidence, was a perfectly fair election. So when we look at the social media posts of Trump in this sphere, we really need to look at the context of the overall conduct that the then president was engaging in, because I think it's quite important that what happens in social media, especially because we talked about how it spills out onto the street. It's not just considered in isolation on the screen, but it's something that's much more important than what a lot of us thought previously. So what then happened, as Dennis also said, and what as you said, this case is presently being decided by the Facebook Oversight Board, and the case is essentially that was Facebook, did Facebook, loosely speaking, lawfully exile Trump from its platforms? So let me just say a couple of things about the Facebook Oversight Board. So it's a relatively new adjudicative mechanism. Its first decisions only were rendered a couple of months ago. Now, I point out that it's run by a trust, so its financial independence is guaranteed by a trust instrument, and its budget is in excess of $100 million. And the members of this board are on, from what I can tell, what's reported is on six-figure salaries. So some of the conditions and the financial resources available to the board, I haven't crunched the numbers, but are probably superior to many of the human rights courts that exist in international law generally. So one of the most interesting aspects of this mechanism is really, as Edoardo, you pointed out, it's a private company setting up an adjudicative mechanism to resolve disputes of a very specific nature. And so far, the jurisdiction of this board is that if there's a post on Facebook or Instagram, it's removed by Facebook for allegedly breaching what we call platform law or Facebook law, then this person or individual can make an application to the Facebook Oversight Board, a little bit like how you approach a court or a tribunal to reverse that decision. Now, Facebook has said that this decision is going to be binding, and there's a lot of nuance there. So maybe we can talk about that later. But to cut a long story short, the board's jurisdiction would not have allowed it to, or rephrasing this, so Trump himself could not have approached the board to overturn Facebook's decision simply because it wasn't a particular post that was removed. Basically, Trump was kicked out of the platform or deplatformed completely. So the only way this case could have gotten to the oversight board was if Facebook referred the case themselves, which they thankfully did. So now we have a situation where the board, I think in the coming weeks, will be deciding whether the decision to deplatform Trump is consistent with Facebook's internal standards and law. And something interesting also to note is that the people on the board who are making these decisions are quite diverse. There's been criticism that the board's not diverse enough, but I've found the board to be fairly diverse compared to other international courts. So we've got a former UNESCO chair on freedom of expression, a Nobel Peace Prize laureate, a Columbia law professor, a former Danish prime minister, amongst others. So it's not just limited to lawyers. It's got sort of technical expertise and expertise in the digital sphere as well. So it's almost interestingly going back to the old days of arbitration, where you just did not have lawyers adjudicating, but also, for example, in construction disputes, you get engineers to come along. So the range of expertise that is sought by the board is really interesting and sort of hybridized in its own sense. So I've written a little bit about this, and I think this is the real test for the Facebook Oversight Board. And it's a very, very difficult situation for the board that it's facing, because it's really between the hard and a rock place. So far, the board has rendered, I think, around 6 decisions, and in 5 of them, it's overturned Facebook's decision, and one of them does include, a female nudity as well, that was briefly mentioned. So it's taken a fairly pro-expression stance. So in one respect, if the same stance is taken again in the Trump case, it might be the case that the decision may be overturned, but it's not as simple. What the Facebook Oversight Board will need to do in this case is to really look at how freedom of expression balances with other rights, in this case, most importantly, democracy. So freedom of expression has never been absolute. There are restrictions to it, and these include incitement to violence, hate speech, and so on. And that's fairly trite. No one disputes that those sorts of restrictions exist in respect of freedom of speech. But there's really 2 issues that I think are really important. One is that what freedom of speech might mean in the US, legally speaking, under their constitutional arrangements, might be quite different from the scope of free speech, for example, in Germany. Then, you've got China and you've got 193 countries. So the precise nuance of what freedom of speech in a particular case actually means is not as uniform as international human rights law or a lot of other scholars might like to think. So that's one thing. The second thing is, and this is quite a practical thing that's especially important in the social media context, is the context of free speech, balancing it with democracy, hate speech, and so on. So American institutions so far have been strong enough that Trump, despite what all went on 6 January, ultimately left office, and now we've got President Biden. There's many countries where the rule of law situation is not as strong as in maybe developed states, or where democracy is much more entrenched. And in those parts of the world, to apply the exact same standards on freedom of speech, which might be influenced by this the oversight board, might actually be quite dangerous, because the institutional strengths in in many parts of the world is not as strong as probably in Europe, US, and other advanced democracies. So I think there's a legal problem and a practical problem. And as was pointed out, I think Maura talked about this before, the entrenched difficulties in defining what is terrorist speech, to differentiate between us and them, and left and right-wing terrorism. We can talk about this more. I've done some work on this as well, so it's quite an interesting discussion. All those legal challenges are going to make it quite difficult for the Facebook Oversight Board to really reach a decision that's going to please everyone. And I'll just end on a brief observation without predicting what the board's going to do. There is another issue with deplatforming generally. So if Trump is kicked out of Facebook, the risk is that, as already seems to be bearing out, that we'll have another social media platform develop, and the bubbles that a lot of us live in might even intensify even more. And if Trump is allowed back on Facebook, then there's a very horrific message sent to other world leaders that you can basically say undermine democracy, pursue hate speech, and there's no consequences. So it's a very difficult balancing act, and that's why I said this is a true test for the oversight board. If they can reach a decision that balances not just the freedom of speech of the speaker, but also the rights of others, and place them at the center of the decision making, and not just as some vague guideline that they may or may not have regard to. That I think will help them build their credibility, and this novel experiment that we're seeing could have a good and positive start, but that remains to be seen. So I'll stop there, Edoardo, and thank you so much again.
Thank you very much, Rishi. And indeed, from a legal perspective, it's really hard to predict the outcome of the oversight board, especially in light of the fact that in the decisions that they've published so far, it seems to me that they have departed slightly from merely applying Facebook community standards, but they've referred to human rights standards. So this might play also a role in the final decision. My personal perspective is that according to Facebook community standards, the deplatforming itself is legitimate. But what is more problematic, in my opinion, is the permanent nature of this measure. So the fact that Trump is prevented permanently from accessing this platform is not something which is included or specified in the community standards. So maybe this is an aspect that the oversight board will discuss. But I've seen that there are some comments here in the chat. So I see a comment from Eugenia. So I would like to ask Eugenia quickly to elaborate this comment, and then I would like to give the word to Dennis to explain the content and the context of the questions that we've received so far in the chat. Eugenia, if you want to.
Yeah, no, just a quick observation, because I was really shocked at the budget given to the oversight board. I was sincerely, really astonished, primarily because, I mean, it's not that they don't deserve it or anything like this. It's just that I'm thinking that Facebook has never kind of paid any kind of compensation no reparations, nothing of the sort, not even like in the horizon of possibilities to anyone that was harmed by its content moderation decisions. And yet it's giving all this money to people who ultimately, out of all these, I suppose, controversial cases, are going to discuss about like one, I don't know, a very small, tiny percentage. I understand that they're very significant when it comes to Trump or another case of Navalny, Russia. But at the same time, I'm very concerned to see this amount of money going to this board without taking into account those that may be harmed by Facebook's decision. So I'll just stop here and see what the audience has to say about all this.
Many thanks, Eugenia. Dennis, bearing in mind that, I mean, the video is now recorded, so for those who will see the video later, so they don't have, of course, the chat. So if you can then rephrase also the question, or if the person who actually wrote the question would like also to take the word and that's the question.
Absolutely. I can read out. There's in fact only one question so far. So please, in the audience, if you do have any other questions, do post them. Amy Ruckus asks, many US politicians have dual social media accounts, private and official accounts. Can we see their various accounts as falling under different regulations, or is the content deserving of the same regulation due to the equal potential for harm? That's a great question, actually. Not only perhaps related to the discipline of law, but particularly.
So I don't know who would like to.
Yeah, I mean, I can have a very, as a lawyer on the panel, I think that have a first crack at this. I'm not sure exactly what the precise rules say. That my sort of legal instinct tells me that if you've got an account, say under individual name X, and then there's an official account, at the end of the day, both those accounts are bound by the rules of the particular platform, regardless of what those rules are. So if a person is trying to circumvent their individual account and then use the say an official account, then I would be astonished if the same rules are not going to apply to both those sets of accounts, because they'll be bound, I would think, by the same legal framework as such.
If I could pitch in there, I think, you know, there's several different rules sets we're talking about here. So for one thing, we have the platform terms of service and community policy. And as far as I remember, at least with Facebook and probably also with Twitter, they mostly refer to public figures, and they have obviously a really specific definition of who counts as a public figure and who doesn't. And there are some really surprising definitional issues there. So yeah, it doesn't really matter if it's an official account or a personal account, you're still a public figure. So, you know, if you have a roughly similar number of followers, then your reach and then the potential for harm is probably quite similar. There's a different set of issues that arises in terms of, you know, if this is an official account, does it mean that it's basically government, you know, the government policy and the position of government? And that obviously has to do with whatever rules apply in particular, you know, sort of state rules or whatever the protocols are, you know, who controls the account, who posts from the account, who has access to the account, and is this a protected phone, et cetera, which, if you remember with Trump, was a huge, there's always a huge set of issues around the security, you know, and, you know, if this counts as the official press voice of the president of the United States, then, you know, what happens if somebody gains control of it and tweets something about a nuclear attack, right? So I think, you know, there's definitely no easy answer to this, is my point. I think Maura might want to add something.
Actually, I might add that just that Facebook recently did ban the Myanmar army, I think, posts. So I think the rules would apply to public accounts as well. And as to the precise detail, I think we'll have to look at the detail. Thanks.
I was going to hop in and say that if we're talking about public versus private accounts, it was Donald Trump's private account that was being used, because it was not the official account of the President of the United States. It was that real Donald Trump, which was a personal account. But what's always been interesting, more interesting to me, is something that Tanya just drew attention to, which is there are rules. It depends for different platforms for public figures, and some also have ones for sort of leaders, political leaders, and this kind of thing. I think the more interesting question, therefore, is not about Donald Trump per se, but it's this question of should politicians, should political leaders be held to a lower standard rather than a higher standard than your common or everyday user. And I have the feeling that if you surveyed just a public or the public or publics, they would think that they should be held to a higher standard potentially, but the platforms are effectively holding them to a lower standard. And it's kind of counterintuitive, because they must be held to, as people have implicitly and explicitly pointed to here, that they have a greater influence. So surely, if you have a greater influence, it matters more if you are president of X country and say something hateful, let's say, versus if you're somebody with 10 followers and say something hateful. But the fact of the matter is, the person with the 10 followers is going to be held to a higher standard than the president of the country. So this is an interesting question, and there's reasons for this, obviously, but you know, I do think this is a question that doesn't get enough attention, and I do think it's a better and broader question than Donald Trump, which gets people really agitated because it's Donald Trump, rather than, you know, a broader discussion about the issues that we're talking about here.
If I may, there are two more questions, and just quickly respond. I think Maura is a very important point. One thing I did just double check, the POTUS account was also blocked, and the Team Trump account was also blocked after they then tweeted something that Twitter deemed violating.
But not permanently.
Right. And there are two questions. The first is from Anne, asking if a domestic national or domestic court bans a political party or statement, does Facebook, is Twitter or social media required to ban the account? That's a very good question. And the second question is posed by Suzanne, who wants us to talk about other platforms, right? We've been talking so far about Twitter and Facebook. There are many out there. What about YouTube, TikTok, Reddit, Pinterest, Spotify, if I may add, Parler, and so on. Is there a legal perspective on which of these are significant enough to, I guess, ban or to talk about?
When the first is a legal question, so I can have a try. These, that is really the fundamental question, the relationship between national, international, and in this case, non-state law, because ultimately Facebook is a company. So from an international perspective, let's say country X bans, makes it illegal to have certain content in their own country. Then if Facebook realistically wants to operate in that country and not be kicked out themselves, they'll have to essentially comply with the law. But it's a very complicated issues about a country's prescriptive jurisdiction. So, you know, sitting, I'm in Dublin, sitting in Dublin, I can enact a law that you're not allowed to throw garbage in the moon. Nothing stopping Ireland from enacting such a law, but how are you going to go and enforce this on the moon? And in the cyber area, and this is why legally this is a very fraught area, jurisdiction is a very, very difficult area to look at. But if Facebook does not have to abide by, I would say, every single piece of national law, regardless of how abhorrent it might be, unless it wants to operate in that particular jurisdiction as well. And that's that's a practical thing. And that's just to add the point that that's another issue with the Facebook Oversight Board jurisdiction, in the sense that Facebook is only going to comply with those decisions as long as they're not inconsistent with national law. So from what I can tell in the rules. So it's going to be quite an interesting perspective to look at, to what extent the decisions can be complied with in terms of how they interact with national law. So I'll stop there. Thanks.
Go ahead, Maura.
Go ahead, Tanya.
No, you go ahead.
I was just going to say very quickly, looking at this from a slightly different perspective. So one of the things that we definitely see happening after the Capitol attacks, and when major and minor companies begin some serious deplatforming of extreme right users, one of the things that happens is a bunch of countries begin to designate various extreme right groups as terrorist organizations. And what this has to do with the question that was just asked is that it's definitely the case that once any type of group has been designated by, in particular, a democratic country as a terrorist group, then most major social media platforms have a greater willingness to take down all of the content and accounts and what have you associated with those groups. So one of the things that made it relatively straightforward for the major social media platforms to take down so-called Islamic State content was that most countries around the world agreed they were a terrorist organization. Many of them designated them as a terrorist organization, and then the content just came down. The issue, so talking about the similarities and differences between the jihadis on one hand and the extreme right on the other hand, is that there are jihadi terrorist groups designated as terrorist groups, jihadi groups designated as terrorist groups by countries all around the world. There's only a handful generally of extreme right groups designated as terrorist groups. So this is one of the reasons why it was more difficult for the companies to take down users and accounts and content associated with movements or groups that really hadn't been designated as, for example, terrorists by anybody. So they had to, they began to engage in their own decision making, but it's more straightforward when countries begin to designate. And indeed, the UK, Canada, Australia have designated a bunch of far-right groups, extreme right groups, in the last weeks and months, in fact.
Yeah, and I'd like to sort of support what Maura says. Is legislation is nice, and national court decisions and laws are also nice to have, but I think platforms are operating under these constraints. Also, it's not just a conversation that platforms are having with states or their legislators or courts, but it's also a much broader field where you also have human rights organizations, you have digital rights organizations, you have minority rights organizations, so you have civil society, and they're all obviously advocating for their own causes. So there's very often platforms are really between a rock and a hard place, but that is also, it can also be a good thing, not an easy thing, but a good thing, because and I keep giving examples from Russia, but that's because it's a really interesting case study. So Russia regularly generates court orders and sometimes even extrajudicial requests to ban certain pages, take down certain accounts, release information about users, or for instance, ban content that violates a law that says you can't publish calls for unsanctioned protest rallies. But so far, specifically with regard to this law, both Facebook and Twitter have largely ignored these requests to take down messages about unsanctioned protest rallies, because obviously they are also facing pressure from free speech organization, opposition activists in Russia. And, so they're trying as much as possible to not react to extrajudicial requests or those court orders that actually, violate kind of broader standards. But they're finding it really difficult. And so far, the only reason they're still managing to do it is because they have no legal entities based inside Russia. So it's much harder to prosecute them or to sanction them. So they've been saddled with some fines. Now Twitter is being throttled in Russia, not very successfully, but so it has slower loading speeds for this exact reason. And there's rumors that Facebook might be next. But it's also interesting, and I think, that next question that we have in the chat, what about other platforms? Right, Facebook and Twitter are based in the US, so they have perhaps a particular perspective and they get more attention. But TikTok, which has different ownership structure, has actually reacted quite well to Russian requests to remove protest-related content, and it's taken down thousands and thousands of posts. Right, so there are differences in how platforms are reacting to these national requirements.
So I was going to say, it's important to say, and I was careful to say democratic countries, because of course, if any platform said that they would take down content accounts, etc., of any group that is designated a terrorist group, well, then there are a bunch of countries around the world who would just go right ahead and designate everyone they don't like a terrorist group or some kind of a terrorist entity or whatnot. And indeed, there are countries that do that already. So it's plainly not any kind of panacea, this whole terrorism thing. It's highly political also. It's more like that in democratic settings, generally, it's a narrow range of groups or entities, individuals, and what have you, who are, designated. There's legislation, there's court rulings, etc., rather than just a broad-based. Anyone who's designated terrorist is taken down because plainly there's a lot of countries that are more than happy to do that. And it raises all kinds of problems and issues.
Many thanks to all the speakers. And indeed, this is the perfect transition to the last part of our workshop, in which will be presented the first findings of the Facebook-funded project, Digital Constitutionalism in Search of a Content Governance Standard. Because you raised in your last comments the fact that essentially it's difficult to understand which standards to apply. Do we need to apply different standards to politicians rather than to ordinary citizens? But indeed, do we need to apply the standards which are set by private platforms if we are talking about sort of like public squares, or do we need to apply human standards, international human rights standards? But there the problem is, what are international human rights standards? Because from a legal point of view, we can agree that we have maybe like regional standards, national standards, but of course there are no internationally agreed human standards. So indeed, this was the starting point of our project, Digital Constitutionalism, which aims to look at what the civil society have said so far. So essentially, we said, so far we have heard from social media platforms, we have heard from lawyers, but let's now look at the conversation that is emerging among civil society groups. So we did an effort from a lawyer standpoint to look at what is happening beyond parliaments, beyond the institutionalized process. And we collected a database of more than 200 documents, non-binding legal documents that we generally call internet bills of rights, which are trying to articulate principles and standards for the digital society. And so far we have completed, Nicola has completed this fantastic job of like coding these initiatives and identifying which principles are emerging specifically related to online content governance. So today we'll have the chance to hear from Nicola, his first findings, of course, preliminary findings of the project. And then we will have the chance also to hear from Kinfe, who is an international lawyer. So Kinfe essentially what has done was to compare the voice of the civil society groups with international human rights standards. So, and just to complete the picture, Dennis then will perform a further comparison with Facebook standards, try to understand if they depart or are in line with what the civil society and international human standards are saying. And then the final outcome of our project will be to publish a series of recommendations to Facebook. But without further ado, I leave the screen then to Nicola. Nicola and Kinfe, you now have, let's say, 5 minutes each to present your preliminary findings. Nicola, the screen is yours.
Okay, thank you, Edoardo. I'm Nicola Palladino, I'm a researcher at DSU. Okay, really, me and Kinfe managed to organize the presentation, giving a brief introduction of the project, and then Kinfe started with his exploration of international human rights law and content governance, and then I will conclude on civil society findings. But I think you already did a wonderful introduction of our project, so I can directly jump to civil society as the finding coming from the analysis of 30 documents drafted by civil society. I analyzed this 40 document. We retraced it. We detected more than 90 different principles. And then we performed some quantitative analysis. I think that I can jump the methodological details, and we can arrive directly, I come to directly to the finding. There are two main findings from this kind of analysis. The first thing is the high degree of consistency among the document that we analyzed. We can say that there is a consensus among civil society, or at least in the sample of civil society initiatives that we analyze, on a common set of principles to be applied to content governance. But even more, there is also a common framework. And the second relevant finding is the absolute centrality of freedom of expression in this framework. Freedom of expression figures as the main concern of civil society while dealing with content moderation. Indeed, freedom of expression is not only the most quoted principle present in almost all the documents we analyzed, but very often also the other principle and standard we detected emerge within discussions about free speech and its limitation, and are in some way subordinated to the safeguard of freedom of expression. It could be sound as obvious, but it is not, because indeed we can imagine that civil society concern like the protection of minority rights may have led to consider other principles as important as freedom of expression, or why not even more important. But instead, the general trend that we found is that competing substantive rights are mainly framed in terms of permissible exception to freedom of expression, which must be exercised according to procedural rules, ensuring that freedom of expression restriction do not degenerate, are not misused or abused, leading to undue censorship practices. I think it's worth noting that this approach is exactly the opposite of the one pursued by government and usually also by platforms that rather aim at identifying and listening the kind of content that could be removed according to competing concerns that are placed on the equal footing of freedom of expression, or regardless for the impact on freedom of expression. The procedural principles advanced by civil society could be distinguished in three subcategories. First of all, we have a series of principles addressed to state that we collected under the label of rule of law. As much in this case, civil society required to government to establish a legal framework providing legal certainty and predictability in content moderation. And this framework should include the definition of freedom of expression restriction according to international human rights law standard. It should also establish under which condition intermediaries is deemed responsible for use of generated content and which kind of action each platform can or must undertake in these cases. And finally, this framework, according to this framework, platform the state should guarantee judicial oversight over content removal and legal remedies. The second categories of principle that we find is relate to good governance principles. That apply to both governments and private companies, and they include transparency, accountability, fairness, participatory decision making. But the most interesting maybe is that the last third category that we found, that are a series of principle recommendations specifically tailored for platform. And most of the time, these are attempts by civil society to contextualize and adapt the very general international human rights standard into more granular norms and rules to be implemented in the platform environment. Okay, I cannot provide you with some much detail about this kind of principle because I realize that I'm late. To conclude, in short, it seems to me that both civil society suggests a clear direction toward which move forward. They suggest to pay attention to the procedural safeguard through which we can ensure that substantive rights, and pay attention also to the processes through which content moderation rules are created and enforced, rather than try to define schematically the boundaries of what is illegal and illegal content. I think it's surely a more complex and hard to implement approach, but probably is an approach capable to achieve a proper balance between competing concerns. Then, that said, I leave the floor to my colleague Kinfe for his report on his exploration on international human rights law. Thank you very much.
Thank you very much, Nicola. I'll be very brief. Just to give you a background, in the past 5-6 years, there have been repeated calls for social media platforms, in particular, to ground their content moderation policies in practices on international human rights law. And many scholars and UN special reporters have also been echoing this point. So the question that I try to address in this project is to see the extent to which international human rights law offers some answers to the challenging questions that we face in content governance. So we arrived to two main conclusions in our study. One is that because international law by design is meant to or is addressed directly to states, and hence doesn't address the private sector like social media platforms, its potential in addressing those key content governance issues is limited. As some of you would be familiar with, international law is primarily addressed to states. States are parties to human rights treaties. That means it's only through their duty to protect, which is a positive obligation, that they have to regulate the private sector. So in that sense, the potential of international human rights law in addressing social media platforms or the private sector generally is slightly limited. And the other finding is that the way in which international human rights standards that are relevant, potentially relevant to content moderation or content governance are couched or framed in general terms. And as Nicola pointed out earlier, unlike civil society initiatives that provide detailed granular rules on issues of content governance, international human rights standards are formulated in general terms that make them less suited to the questions that arise, human rights questions that arise in the context of content governance. And of course, there have been various attempts to unpack and to contextualize these international human rights standards to the social media content governance context. But you know, the legal value of these interpretations offered by civil society organizations, UN special rapporteurs, so on and so forth, is slightly contentious, because they are not binding interpretations, and they cannot be imposed on social media platforms to apply them in their content governance practices. So due to these two factors, international human rights law, despite the recent interest in having its standards applied in content governance, has a very limited potential. But as Nicola addressed earlier, international human rights standard provided the basis for the most recent civil society initiatives in the field of content governance, even though international human rights law had states at its target. Much of the recent civil society initiatives draw upon these age-old rights and principles in trying to contextualize international human rights standards to content governance. So that is our broader finding, is that unless social media platforms subscribe to these civil society developed social content governance standards, there is no way to ensure that they follow them in practice. So that's generally, in the interest of time, I'll stop there. Thank you very much.
Thank you very much, Kinfe. And now I would like to open the floor for questions or comments related to what Kinfe and Nicola have presented, but also we have a couple of minutes if you want to follow up on some of the questions that were previously raised by the speakers of the roundtable. Yes, I see that Eugenia. Yes.
Yeah, I have a couple of questions. This was very interesting. Thank you very much. The question I have is about the methodology of which kind of civil society organizations did you decide to focus on, and what criteria you used for this. And the second is that I have, because from what I see, you have assumed that civil society is a kind of a unitary actor, I suppose, whereas there are kind of tensions within civil society groups. I was also in a panel recently where one of the papers that was presented showed the ways in which different civil society actors in the context of the US are actively lobbying Facebook. And in fact, their finding, the Brenda Dvorak, her name is from Harvard University, her finding was that in the exact opposite, that it wasn't, were you there in that panel, Nicola? Anyway, so for everyone else, I will summarize the main finding of her study was that an actor such as the Anti-Defamation League, which would be opposed to absolute freedom of speech, had more power because they were more organized, and Facebook policies conformed to that particular perspective, which she attributed to the more power that the civil society actor had. So this is basically my question.
Nicola, I don't know if you would like to take this question.
Yes, of course. But it's really funny because I attended the same presentation, and I made a question about methodology to the presenter, because indeed I was curious why our results are different. And I think that the solution is in the methodological criteria that we use it, because the president of the panel made interviews with the civil society activists. So our approach was different. We, as Edoardo said before, we build a digital constitutionalism initiatives database. In a joint effort with the Working Group on Digital Constitutionalism at the Center for Advanced Internet Studies in Bochum. And so we collected more than 200 documents, and the criteria through which we selected this document, and that they have what we call that constitutional language. So they have to refer to, write, they have to the aspiration to establish rights and constitutional norms. And then among these documents, we selected the one that also deal with content governance in some way. Okay, of course, I think that the kind of civil society association that engage in the challenge to draft a digital bill of rights, an internet bill of rights, probably give more importance. Its focal point is freedom of expression, or at least it comes by an history in which freedom of expression was the most important topics. But I imagine that there are different kind of civil society organizations. There are civil society organizations that may be more interested on minority rights. And then I think that concern about freedom of expression are not so important, or at least not have the supremacy in a hierarchy of rights and principles to protect. So, but among the little universe, the sample of civil society organizations that decide to engage in the enterprise to write this kind of document, this digital rights charter, internet bill of rights, and so on, we found a high degree of consistency. And a degree of consistency that is regardless for the location of civil society organizations. So we found that African civil society organizations say more or less the same things of European, American, or Asian civil society organization. They have the same reference, because the reference is international human rights law. A lot of these documents quote in their text some article of some international human rights law instrument. I was surprised by these findings, but it's very solid results of our empirical analysis.
Many thanks, Nicola, and I also would like to add that Nicola and Kinfe drafted 2 preliminary reports of the research, and we will make them available soon on a website that we are creating. So we would really look forward also to receiving your comments and feedback on them. We are now running out of time, but I see that Rishi raised his hand, so maybe we have like 1 minute for a final quick question. Rishi.
Yep, thanks. So my question really is about the role of human rights. So my understanding is that the preliminary conclusion, at least, is that they have limited effects. To what extent are you taking account the early jurisprudence of the oversight board, where, you know, despite what all you've said, human rights in the reasoning is actually proving quite critical?
Kinfe, would you like to take this question?
Yes, thank you very much for the question. So we have not yet included the decisions of the Oversight Board, because the reports was produced quite early on. So, but we intend to include that, because I am aware the Oversight Board had made reference to international human rights standards in their reasoning. So that would be
yeah, and they've been quite critical. So I think that's quite an important point, because that would really determine the future direction in many ways as well, depending on how successful the board is. Thanks.
Yes, and also in relation to this point, we'll have also to understand the significance and the impact of the decisions of the Oversight Board, because we have also to remember that, of course, the Oversight Board does not decide all the online content governance cases that daily emerge in the Facebook platform, but of course they only decide like a selection of these cases that are either referred by Facebook or directly appealed from the users. So definitely many thanks, Rishi, also for this feedback. That is something that we will take care of integrating in our report. So it's now time, unfortunately, to conclude this online event. I would like to thank once again all the speakers for taking the time actually to join us today, the participants, and my colleague Marieke Mooij from the Dublin Law and Politics Review for helping us organize this event. So we'll make then the recording available on YouTube. And thanks once again for joining us today. Have a very nice day.
Thank you. Thanks.